Meeting of Parliament, Wednesday the 15th of February 2023. Order of the day. Bills, first and second reading. A bill for an act to amend the Medical Group Practice Scheme Act to ensure that the dependents of persons registered on the Group Practice Medical Scheme by the virtue of undertaking a full-time academic course at the University of Gibraltar will not be considered dependents under the Medical Group Practice Scheme Act. The Honourable, the Minister for Digital, Financial Services, the Health Authority and Public Utilities.
Mr. Speaker, I have the honour to move that a bill for an act to amend the Medical Group Practice Scheme Act to ensure that the dependents of persons registered on the Group Practice Medical Scheme by virtue of undertaking a full-time academic course at the University of Gibraltar will not be considered dependents under the Medical Group Practice Scheme Act be read a first time.
I now put the question, which is that a bill for an act to amend the Medical Group Practice Scheme Act to ensure that the dependents of persons registered on the Group Practice Medical Scheme by virtue of undertaking a full-time academic course at the University of Gibraltar will not be considered dependents under the Medical Group Practice Scheme Act be read a first time. Those in favour? Those against? Carried.
The Medical Group Practice Scheme Amendment Act 2022.
Mr. Speaker, I beg to move that the bill for the Medical Group Practice Scheme Amendment Act 2022 be read a second time. This short bill introduces the changes required in order to establish that a person will not be able to register on a medical group practice scheme established under the Medical Group Scheme Act by virtue of being the dependent of a student enrolled on a full-time academic course at the University of Gibraltar. The bill, in conjunction with supporting amendments to its subsidiary legislation, as well as the Bill for Immigration, Asylum and Refugee Amendment Act 2022, will put the University of Gibraltar on a competitive financial footing with its counterparts in the UK by offering those on a full-time academic course at the university who also require private medical insurance the option to pay for access to our own medical scheme. These changes are beneficial to all parties involved and are a clear sign of government's continued commitment to Gibraltar and its educational institutions. Mr. Speaker, I commend this bill to the House.
Before I put the question, does any honourable member wish to speak on the general principles and merits of the bill? The Honourable Elliot Phillips.
Mr. Speaker, I thank the Honourable Minister in relation to his explanation. He did kindly explain the rationale yesterday, and this bill will enjoy the support of the opposition.
Does any other honourable member wish to speak on the general principles and merits of the bill? I'll ask the Honourable Daniel Feetham.
Mr. Speaker, I just haven't understood this, and I just appreciated the Honourable the Minister might explain by reference to just an example that I'm just going to put to him, because honestly I just haven't understood the purpose of the bill. So, for example, if somebody one of our children, university, God forbid, contracts something like cancer or something like that, would they be able to be treated through the GHA in the normal way, in other words, at public expense in Gibraltar, or would they, because they're at full-time education at university, then have to go through the NHS in the UK, which, God forbid, is in a worse state than the GHA here in Gibraltar?
Honourable Gilbert Likudi.
Mr. Speaker, thank you. The explanatory memorandum talks of somebody not being a dependent for the purposes of the Medical Group Practice Scheme Act by virtue of being a dependent of a person enrolled at the University of Gibraltar on a full-time academic course. The actual amendment that is being made refers to someone who is enrolled at the University of Gibraltar on a full-time academic course who has been charged and paid the student health surcharge to the University of Gibraltar. Could I ask the Minister simply to confirm that the reference to persons on a full-time academic course in Gibraltar does not include those Gibraltar residents who are already part of the scheme, notwithstanding that they are part of the full-time academic course, enjoying a full-time academic course in the university. In other words, there may be circumstances where there may be foreign students who come and undertake a full-time academic course at the University of Gibraltar. They are charged the student health surcharge, and therefore their dependents are not entitled to be treated as dependents for the purpose of the scheme. So it is not the case, and I would just ask the Minister to clarify that it is not the case that this applies to any person carrying out a full-time academic course, for example, the children of Mr. Feetham or anybody else who is enrolled under the scheme, but only those who come from abroad and are charged this particular surcharge.
Does the mover of the bill wish to respond?
Yeah, Mr. Speaker, I'll respond. I will confirm to my honourable friend and colleague, Mr. Likudi, that that is indeed the case. The bill solely strikes at those who are not already members of the GPMS scheme and who come from outside and therefore are not otherwise eligible for membership to the scheme to become members of the scheme if they make the contribution and if they're in full-time education at the University of Gibraltar. That is the sole purpose of the bill, and that is the only people that are affected by it. I'm not sure I quite understood the honourable member's question. This has no impact on any of our students outside. It simply applies here in Gibraltar in respect of those coming into the jurisdiction, not members of the scheme, who wish to be members of the scheme. They will have to pay both full-time education and the contribution. I hope that. Thank you.
I now put the question, which is that a bill for an act to amend the Medical Group Practice Scheme Act to ensure that the dependents of persons registered on the Group Practice Medical Scheme by virtue of undertaking a full-time academic course at the University of Gibraltar will not be considered dependents under the Medical Group Practice Scheme Act be read a second time. Those in favour? Those against? Carried.
The Medical Group Practice Scheme Amendment Act 2022.
Mr. Speaker, I beg to give notice that the committee stage and third reading will be taken today if all honourable members agree.
Do all honourable members agree that the committee stage and third reading of the bill be taken today?
A bill for an act to amend the Gibraltar Merchant Shipping Safety etc. Act 1995 in order to extend the functions of the Maritime Administrator for the purposes of compliance with instruments of International Maritime Organization, and in particular, the IMO Instrument Implementation Code, 3 Code Resolution A, full stop, 1070/28. The Honourable the Minister for Business, Tourism and the Port.
I have the honour to move that a bill for an amendment, for an act to amend the Gibraltar Merchant Shipping Safety etc. Act 1995 in order to extend the functions of the Maritime Administrator for the purposes of compliance with instruments of the International Maritime Organization, and in particular the IMO Instrument Implementation Code, III Code Resolution A 1070/28 be read a first time.
I now put the question, which is that a bill for an act to amend the Gibraltar Merchant Shipping Safety etc. Act 1995 in order to extend the functions of the Maritime Administrator for the purposes of compliance with instruments of the International Maritime Organization, and in particular the IMO Instrument Implementation Code, 3 Code Resolution A107028 be read a first time. Those in favour? Those against? Carried.
The Gibraltar Merchant Shipping Safety etc. Amendment Act 2020.
Mr. Speaker, I have the honour to move that a bill for an act to amend the Gibraltar Merchant Shipping Act 1995 be read a second time. The bill, together with the next bill on the order paper to amend the Gibraltar Port Authority Act 2005, introduces obligations on the Gibraltar Maritime Administrator and Gibraltar Port Authority, respectively, to A, assign responsibilities to monitor, update and revise policy in order to comply with International Maritime Organization obligations, and B, to advise the government on the legislation, guidance and procedures required to ensure the consistent implementation and verification of the IMO obligations. In short, this bill and bill to amend the Gibraltar Port Authority Act 2005 imposes duties on the Gibraltar Maritime Administrator and Gibraltar Port Authority to ensure that laws and policies are implemented as required by the IMO. The reason why the amendment is required in both acts is because each act deals with different areas of responsibility, which broadly align with the different responsibilities held by the Gibraltar Maritime Administrator and the Gibraltar Port Authority. Mr. Speaker, the Gibraltar Merchant Shipping Safety etc. Act imposes obligations on the Maritime Administrator, a statutory post which heads the Gibraltar Maritime Administration. The GMA is responsible for what is described in the maritime industry as flag state and port state matters. The term flag state refers to matters of vessel registration and compliance with standards required in order to be registered under the Gibraltar flag and to maintain that flag. The term port state addresses the responsibility to exercise prospective and enforcement action over foreign vessels within the Gibraltar port. The amendment to the Gibraltar Merchant Shipping Safety etc. Act therefore imposes on the GMA the obligation to ensure the implementations of laws and policies in relation to flag state and port state matters. Mr. Speaker, I commend the bill to the House.
Before I put the question, does any honourable member wish to speak on the general principles and merits of the bill? The Honourable Elliot Phillips.
Mr. Speaker, again, in relation to this bill, the Honourable Minister has consulted with us on a number of occasions now, given the certain complexities in relation to this bill, and I'm happy that the opposition will support the bill.
Does any other honourable member wish to speak on the general principles and merits of the bill? I call on the mover to respond.
Mr. Speaker, I'd like to thank the Honourable Mr. Phillips, who's been very helpful, and we spoke a couple of times, and happy for the support of the opposition. Thank you.
I now put the question, which is that a bill for an act to amend the Gibraltar Merchant Shipping Safety etc. Act 1995 in order to extend the functions of the Maritime Administrator for the purposes of compliance with instruments of the International Maritime Organization, and in particular the IMO Instrument Implementation Code 3 Code Resolution A107028 be read a second time. Those in favour? Those against? Carried.
The Gibraltar Merchant Shipping Safety etc. Amendment Act 2020.
I beg to give notice that the committee stage and third reading of the bill be taken today if all honourable members agree.
Do all honourable members agree that the committee stage and third reading of the bill be taken today? Aye.
A bill for an act to amend the Gibraltar Port Authority Act 2005 in order to extend the functions of the Gibraltar Port Authority for the purposes of compliance with the instruments of the International Maritime Organization, and in particular the IMO Instrument Implementation Code 3 Code Resolution A107028. The Honourable the Minister for Business, Tourism and the Port.
I have the honour to move that a bill for an act to amend the Gibraltar Port Authority Act 2005 in order to extend the functions of the Gibraltar Port Authority for the purposes of compliance with instruments of the International Maritime Organization, and in particular the IMO Instrument Implementation Code, III Code Resolution A107028 be read a first time.
I now put the question, which is that a bill for an act to amend the Gibraltar Port Authority Act 2005 in order to extend the functions of the Gibraltar Port Authority for the purposes of compliance with instruments of the International Maritime Organization and in particular the IMO Instrument Implementation Code 3 Code Resolution A107028 be read a first time. Those in favour? Those against? Carried.
The Gibraltar Port Authority Amendment Act 2020.
Mr. Speaker, I have the honour to move that a bill for an act to amend the Gibraltar Port Authority Act 2005 be read a second time. The Gibraltar Port Authority Act 2005 establishes the Gibraltar Port Authority and details the duties and responsibilities to be undertaken by it. The nature of the responsibilities carried out by the Gibraltar Port Authority are described in the maritime industry as coastal state matters. This term incorporates areas such as ensuring the safety of navigation to protect and the environment, guarding against maritime pollution and protection of the security of coastal populations. The amendment to the Gibraltar Port Authority Act 2005 therefore imposes on the GPA the obligation to ensure the implementation of laws and policies in relation to coastal state matters. Mr. Speaker, I commend the bill to the House.
Before I put the question, does any honourable member wish to speak on the general principles and merits of the bill? The Honourable Elliott Phillips.
Mr. Speaker, briefly, the opposition will support the bill.
Does the honourable member wish to respond?
Speaker, once again, I'm grateful to the Honourable Mr. Phillips, who once again we discussed this yesterday and on a few occasions before that. Thank you very much.
I now put the question, which is that a bill for an act to amend the Gibraltar Port Authority Act 2005 in order to extend the functions of the Gibraltar Port Authority for the purposes of compliance with instruments of the International Maritime Organization and in particular the IMO Instrument Implementation Code 3 Code Resolution A107028 be read a second time. Those in favour? Those against? Carried.
The Gibraltar Port Authority Amendment Act 2020.
I beg to give notice that the committee stage and third reading of the bill be taken today if all honourable members agree.
Do all honourable members agree that the committee stage and third reading of the bill be taken today?
Committee stage and third reading. The Honourable the Chief Minister.
Mr. Speaker, I have the honour to move that the House should resolve itself into a committee to consider the following bills clause by clause. The Medical Group Practice Scheme Amendment Bill 2022, the Gibraltar Merchant Shipping Safety etc. Amendment Bill 2022, and the Gibraltar Port Authority Amendment Bill 2020. Sorry, both are 2020.
A bill for an act to amend the Medical Group Practice Scheme Act to ensure that the dependents of persons registered on the Group Practice Medical Scheme by virtue of undertaking a full-time academic course at the University of Gibraltar will not be considered dependents under the Medical Group Practice Scheme Act. Clauses 1 to 3.
Mr. Chairman, just in relation to the time, I assume they get picked up in for 2023. I no need to make reference to them.
Grateful that you have brought it up. The title, the Act, it's shown as 2022, and what the Honourable Gentleman is saying that should be amended to read 2023.
Mr. Speaker, in fact, we have this discussion on a number of occasions. The bill has the date of publication. The Act, when it is passed, is published with the date of publication, of passing of the Act. It's not a point that we need to make. I'm grateful that it's made, but we don't need to make it.
Clauses 1 to 3 stand part of the bill.
The long title.
The long title stands part of the bill.
A bill for an act to amend the Merchant Shipping Act and the Gibraltar Merchant Shipping Safety, etc. Act 1993. Clauses 1 to 4.
Clauses 1 to 4 stand part of the bill.
Sorry, Mr. Chairman. Are we dealing with the Gibraltar Merchant Shipping Safety Act? Just one point. In relation to Clause 4, I would propose a very minor amendment. At the very end, it says, for the purpose of this subsection, the Maritime Administrator may arrange for the discharge of any of its functions. And it seems to me that it should say any of his functions. The Maritime Administrator is an individual. And in fact, the Gibraltar Merchant Shipping Registration Act provides that the Minister shall appoint and may remove an officer to be styled the Maritime Administrator and confer upon him powers, and therefore this should say any of his functions rather than its functions.
Honourable lady.
Instead of his, it could well be a female or a male.
Mr. Chairman, as I understand it, the Interpretation General Clauses Ordinance Act deals with that, and in fact, the legislation that we have in relation to the Maritime Administrator all deal with his functions and anything that is conferred upon him. And clearly, when we say he in legislation, he includes she or them.
Honourable Elliot Phillips, do you have a... No, fine. Clause 4, as amended, stands part of the bill. Long title
The
stands
long
part.
title.
The long title stands part of it.
A bill for an act to amend the Gibraltar Port Authority Act 2005 in order to extend the functions of the Gibraltar Port Authority for the purpose of compliance with instruments of the International Maritime Organization, and in particular, the IMO Instrument Implementation Code 3 Code Resolution A 1070/28. Clauses 1 to 4.
Clauses 1 to 4 stand part of the bill.
The long title.
The long title stands part of the bill.
The Honourable, the Chief Minister.
Mr. Speaker, I have the honour to report that the Medical Group Practice Scheme Amendment Bill 2020, the Gibraltar Merchant Shipping Safety, etc. Amendment Bill 2020, and the Gibraltar Port Authority Amendment Bill 2020 have been considered in committee and agreed to with some amendments, and I now move that they be read a third time and passed.
I now put the question, which is that the Medical Group Practice Scheme Amendment Bill 2022, the Gibraltar Merchant Shipping Safety, etc. Amendment Bill 2020 as amended, and the Gibraltar Port Authority Amendment Bill 2020 be read a third time and passed. Those in favour of the Medical Group Practice Scheme Amendment Bill 2022? Aye. Those against? Carried. Those in favour of the Gibraltar Merchant Shipping Safety, etc. Amendment Bill as amended 2020? Aye. Those against? Carried. Those in favour of the Gibraltar Port Authority Amendment Bill 2020? Those in favour? Aye. All right. Those against, carried.
Private member's motion. The Honourable E.J. Phillips.
Speaker, apologies. I have the honour to move the motion standing in my name, which reads as follows. This House notes that Gibraltar legislation does not currently provide for a legal right to paid leave for parents who are grieving the loss of a pregnancy before 24 weeks. Notes that His Majesty's Government previously introduced a legal entitlement to 2 weeks paid leave for working parents in respect to the loss of a child of any age or those who suffer a stillbirth from 24 weeks of pregnancy, commonly referred to as Jack's Law. Notes the introduction of groundbreaking legislation in New Zealand to provide workers with 3 days paid leave in the event of miscarriage. Notes that a bill for the provision of miscarriage leave has been presented by Angela Crawley, Member of Parliament for Lanark and Hamilton East, before the British Parliament. Notes that the loss of a baby by miscarriage is a devastating experience for families, and for some in our community, miscarriage is tragically not a singular event. Notes that whilst employers and organisations in Gibraltar are sensitive to the grief and loss associated with miscarriage and may have made provision in the context of their employment policies and practices, it is important that support by way of paid leave be enshrined in Gibraltar law for those persons who have suffered the devastating loss of a pregnancy before 24 weeks, and calls on His Majesty's Government to present either 1, a bill before the House to make provision by way of Roman 1, the introduction of new legislation, or 2, amendment to employment and or benefits legislation for paid leave for people who have experienced miscarriage, ectopic pregnancy or molar pregnancy, or in the alternative to amend secondary legislation such as, for example, the Employment, Maternity and Parental Leave and Health and Safety Regulations 1996, amongst others, pursuant to powers provided to the Minister responsible under any acts, to widen the scope of the same to make provision for paid miscarriage leave.
Because at this stage, you simply speak on the motion.
I know, Mr. Speaker, I think the question, of course, because obviously I filed an amendment to the motion to extend miscarriage leave insofar as those pregnancies where it was recognised by a medical practitioner and advised by a medical practitioner that they were not viable. But I think that I've sort of spoken with the learned leader of the opposition, and he will introduce that amendment at the relevant time, but I certainly can make my main contribution now.
Please proceed.
On the motion, it is important for us to reflect. It is important for us to reflect on the route that this motion has taken. On Monday, the 6th of February 2023, some 10 days ago, I filed a motion on the terms I have set out, and I emailed both the Chief Minister and the Honourable Lady, copying in the Leader of the Opposition, to ensure that we secure cross-party agreement to the motion standing in my name. I remain confident that the motion can and indeed should enjoy cross-party support because it ensures that those who suffer the devastating effects of pregnancy loss up to 24 weeks can be provided with support in the form of paid bereavement leave. There can, in my view, be no justification on any objective analysis for the government not joining with the opposition and the Honourable Lady on this issue, and any disagreement on the principle is simply playing party politics. Mr. Speaker, by way of background, I filed a motion on this subject because it is the right thing to do, and I've been previously encouraged by the Chief Minister himself to use this parliamentary process as a more efficient way rather than utilising a private member's bill. In the past, Mr. Speaker, the Chief Minister has attempted to dissuade me from using a private member's bill, given that the opposition do not have at their disposal a drafting team, which is of course readily available to the government. On that occasion, I agreed and proceeded by way of motion. I have sought to repeat the same process, allowing the government to lead on the legislative process. It now seems likely that I'm about to be criticised for introducing a motion and doing my job for my community. It was suggested by the Honourable the Chief Minister yesterday that he was not happy that I did not obtain his consent to file a motion. That comment yesterday from him, Mr. Speaker, the Chief Minister, was disappointing, and I expected better, particularly given that we were talking about bereavement loss. Mr. Speaker, it has never, thankfully, been the custom or practice of this House for a member of this House to seek the Chief Minister's consent to file a motion, and therefore the Chief Minister's emotional response from a sedentary position should be of deep regret to anyone who purports to have democratic interests of this community at their core. Whilst I do not seek Chief Minister's consent, which I am in any event not required to do, I did extend him the courtesy of now 10 days to reflect on the government's position and provide the honourable members opposite the opportunity to support my motion, which in light of yesterday's skirmishes in this House on timetabling is, as I'm sure Mr. Speaker will agree, more than reasonable. I am pleased to report to this House that my motion enjoys the support of the Honourable Lady, who has constructively engaged with me on this subject, and I thank her for her collaboration and look forward to her contribution this evening. I also look forward to further collaborating with the Honourable Lady on areas which are collective good for our community. Mr. Speaker, pregnancy loss at any stage of a pregnancy can have a devastating effect on any couple expecting the birth of a child. Statistically, 1 in 8 pregnancies result in miscarriage, 1 in 90 are ectopic, and 1 in every 20 is a stillbirth. Tragically, some people have experienced all three. For a number of families, pregnancy loss or miscarriage before 24 weeks is sadly not a one-off occurrence, doubling the pain and suffering for those who have gone through that experience. It is right that we as a community recognise that parents in these circumstances may need additional support, and I have no doubt that workplaces and organisations around Gibraltar understand the trauma and the need to allow parents the time and space to grieve the loss of a pregnancy. As this House has recognised previously, the government committed to the introduction of bereavement loss for pregnancies beyond 24 weeks. The government went beyond that provision that was provided for in the United Kingdom, and they recognised that bereavement should apply irrespective of the age of the child, be it 25 weeks, 18 years, or indeed 37 months. And I congratulate the honourable members opposite for extending that beyond the 24-week period. As the law currently stands, there is no legal entitlement to any leave or pay in circumstances where the pregnancy loss occurs before 24 weeks. What my motion seeks to do today is simply to encourage the government to recognise that the trauma associated with pregnancy loss can happen at any stage of pregnancy, and therefore it is right that this House promotes primary or secondary legislation that introduces an entitlement to paid bereavement leave before 24 weeks. What I am essentially asking for, Mr. Speaker, is for the government to close the gap. As the position currently stands, we are leaving to employers and organisations to add pregnancy loss to their policies and to make reasonable adjustments where necessary. As a community, we have not tackled this question, but it has been and is being addressed in other countries, including the United Kingdom, where the bill is going through the various stages in the Westminster Parliament. Thus far, those countries who have not introduced a provision for statutory paid bereavement leave have, as I have just said, left the matter to individual companies to extend pregnancy loss bereavement as an employee benefit. In my view, providing employers with the choice or discretion as to whether they wish to create or extend their own benefit schemes and employment policies to make provision for bereavement leave before 24 weeks can create a two-tier system where larger and more competitive industries are likely to offer more enhanced benefits as opposed to smaller employees who may wish, for whatever reason, not to make the provision. We cannot allow, Mr. Speaker, for a two-tier system to be created, and we must make provision for a level playing field in respect of this. We cannot leave it to the discretion of employers as to whether they will support working parents who suffer loss in this way, and it is right that statute and or regulation intervene in this way, as I have suggested. Lastly, Mr. Speaker, I would like to publicly acknowledge the hard work of Baby Steps Gibraltar, who have campaigned on this issue in the past, and to express my deep sympathy to all parents who have suffered and are suffering the loss of pregnancy in our community. It is hoped that this small but very important provision will go some way in supporting grieving parents in the workplace. I commend my motion to the House, Mr. Speaker.
I now propose the question in the terms of the motion moved by the Honourable E.J. Phillips. The Honourable, the Leader of the Opposition. We're going to deal with the amendment first. Yes.
Mr. Speaker, as my honourable colleague to my right indicated, after further reflection, and I believe a draft of this has been circulated to honourable members in the House with the tracked change, we're moving an amendment to the motion that stands in my colleague's name to add the words "or where a pregnancy is determined by a medical practitioner to be unviable before 24 weeks" in the in which paragraph? In the last paragraph. Is it the last paragraph?
Yes, last paragraph.
Yes, in the last paragraph, and striking out the "or" before molar. I think the honourable members have a copy of this letter dated the 14th of February in front of them. They should have a copy of it, and the reasons are as explained by my honourable colleague.
I now propose the question in terms of the amendment moved by the Leader of the Opposition. Put the question in terms of the amendment moved by the Leader of the Opposition. Those in favour? Those against? Carried. What the House now has before it is the original motion as amended. Does any honourable member wish to speak on the motion? The original and the amendment. The Honourable the Chief Minister.
Mr. Speaker, this motion comes before the House with the government having been given notice of it, but not having been not having been consulted on whether or not we would support it if it was brought. I think it's important that I deal with that issue because I have never asked any member of this House, indeed even on this side of the House, that they should seek my consent before they do any of the things that they are empowered and indeed required to do by their membership of the House. There is a difference between seeking consent for something and seeking support for something. When a member of the government wants to move a bill, what they do is they come to the cabinet and they discuss with others whether or not this is in keeping with the policies that we believe in. And we have a good feel for what we are defending, and we are usually on the same page on these subjects, and if we're not, we consider them and we find a consensus position. When members are on the opposite side of the House and they represent, or should represent, different principles and ideologies to us, and if they want to come to the House with a measure, be it a legislative or a motion, they know that it will prosper and succeed only if there is support from the government benches. Indeed, Mr. Speaker, that support does not have to be from us as a government. It can be from individual members on issues where members may be free to vote as they wish, as they always are. So I have never suggested that the Honourable Mr. Phillips or anyone else should seek my consent before they move a motion. I've asked that they should consider seeking the government's support before moving a motion, because it may be possible that a motion moved with some amendment that doesn't affect the underlying substrata of principle may move with full support of the government, that is to say, the 9 votes on this side, and indeed potentially the vote of the Honourable the backbencher also, if it is something that we have discussed and our support has been sought for. If our support is not forthcoming, honourable members can still put the motion, and we will have a debate on the floor of the House of why we don't support it or seek to amend it in a way that it is supportable. That is not consent, Mr. Speaker. It is erroneous entirely for the honourable member to have suggested to this House that I have sought that he seek my consent for anything. I would ask him to reflect on that and to withdraw that when the time comes, because nothing that I have said in this House, and we have had this debate on a number of occasions, and nothing I have said outside of the House can ever be interpreted as me saying that my consent is necessary for a motion to be moved. If the honourable member does not want to withdraw that, I have no difficulty with him not doing so, because the record shows what I have said. So, Mr. Speaker, this motion, which deals with an issue on which there can be support from this side of the House, was moved by the honourable member, giving me notice that he had moved it, but not asking me whether we would support it. Indeed, he didn't ask the Minister for Justice whether it was a measure that would enjoy her support, or the Minister for Industrial Relations and Employment whether it's a measure that would enjoy our support in respect of an area of his policy. But that is a matter entirely for him. I therefore do not believe, Mr. Speaker, it is fair either to suggest that I had an emotional response or reaction to the honourable gentleman's reference across the floor of the House yesterday, with microphones off, as to whether or not I would be supporting the motion. And indeed, my support is not relevant. The support that is relevant, the support of my honourable colleagues and the government. I wasn't in tears. I didn't show any other emotional affliction. And so I put it to the honourable gentleman, it's unfair for him to refer to what he says was my factual reaction as an emotional one when it wasn't. So, Mr. Speaker, for all of those reasons, the part of the honourable gentleman's speech which he has devoted to denigrating my approach to this particular parliamentary procedure, I think is not just unfair, I think it is factually entirely wrong, and I do hope that we don't have to spend more of this debate dealing with that issue. I'm delighted to hear that the Honourable Lady is going to be constructively involved in this debate and that she's going to be supporting this motion. I'm also hoping to demonstrate that the government would have given support if the honourable gentleman had called me before he had put the motion to a motion that I would have asked him to amend in some ways, which would have been then a motion, given his track record in other matters in this House, that we could have moved with full government support. But in any event, Mr. Speaker, I do believe that the honourable gentleman has said something which is absolutely true, important, relevant, and of which we must take notice. That there is a gap in our law for those who lose a child before 24 weeks of gestation. It is true that other countries are now turning their attention to that, and we have not yet done so because we have an eye to what is happening in the United Kingdom and has not yet happened. It is also true, Mr. Speaker, that we have done very positive work with the ladies who and those who run Baby Steps, and the fruit of that work is already in our legislation and in the approach that we take within the government service to those who may find themselves losing a child before 24 weeks gestation and after 24 weeks gestation. So, Mr. Speaker, the position of the government is going to be to propose to amend the motion. And to amend the motion in a way that I hope honourable members will see is not designed to do anything other than to address the issue that the Honourable Mr. Phillips has himself referred to, which is to close the gap, but to close the gap fully. Not to close the gap and leave another gaping hole. Mr. Speaker, first of all, in the second paragraph, and I will give honourable members written notice of this in a minute, I will propose that the second notes should say notes and welcomes, that His Majesty's government, and not previously, but in 2020, to set that in its proper chronological context. Mr. Speaker, in that respect and in respect of that amendment that I'm going to propose, I refer the House, Mr. Speaker, to press release number 44 of 2020 and press release 75 of 2020. Press release number 44 of 2020, issued by the government, was headed "Bereaved Parents to be entitled to 2 weeks of paid leave from work," and said this: Her Majesty's Government of Gibraltar, as we then happily were, is set to introduce a Jack's Law, under which bereaved parents will be entitled to 2 weeks of paid leave from work. In the UK, this initiative became known as Jack's Law, in memory of Jack Hurd, whose mother, Lucy Hurd, campaigned relentlessly on the issue. Under Jack's law, working parents who suffer the devastating loss of a child under the age of 18 or who suffer a stillbirth from 24 weeks of pregnancy will be entitled to 2 weeks statutory leave. Parents will be able to take the leave as either a single block of 2 weeks or as two separate blocks of 1 week, each taken at different times across the first year after their child's death. This means they can match their leave to the times they need it most, which could be in the early days or over the first anniversary. This proposed initiative follows the UK Parental Bereavement Leave and Pay Regulations, which are planned to come into effect on the 6th of April 2020. However, the implementation date for Gibraltar will be the 1st of February 2020. And then I said something in that press release, Mr. Speaker. On the 11th of February, Mr. Speaker, we had considered the matter further, and we said as follows in press release number 75, Jack's law to apply to all children regardless of age. So this is going in the other direction, Mr. Speaker, not under 24 months. Last month, Her Majesty's Government of Gibraltar announced it was set to introduce Jack's law under bereaved parents, under which bereaved parents would be entitled to 2 weeks of paid leave from work. This legislation had become known as Jack's law in the UK, in memory of Jack Hurd. In its original announcement, the Government of Gibraltar specified that under Jack's law, working parents who suffer the devastating loss of a child under the age of 18 or who suffered a stillbirth from 24 weeks of pregnancy would be entitled to 2 weeks of statutory leave. Parents would be able to take the leave as either a single block of 2 weeks or as two separate blocks of 1 week each, which could be taken at different times across the first year after their child's death. This meant that parents could match their leave to the times they needed it most, which might be in the early days or around the first anniversary. However, the government feels that the parents' pain and suffering are the same whether the child is 17 or 37. And so it is now decided to remove the threshold of 18 years of age. Jack's law will apply no matter what the age of the child, and as a result, bereaved parents of adult children will also be entitled to 2 weeks of statutory leave. The amended regulations will take effect from April. So, in 2020, Mr. Speaker, we moved to change our law so that anybody who lost a child over 24 weeks gestation, and whatever the age of that child, 18, 38, or 68, well, I mean, 68 probably the person wouldn't be working, but it's possible, would be entitled to leave. The period in question, therefore, is the period now below 24 weeks. But it's important that when we are welcoming that, Mr. Speaker, that change in respect of the period over 24 weeks, we reflect in the motion when it was done in 2020. Then I would propose, Mr. Speaker, after the second paragraph, to introduce a new paragraph. Notes that His Majesty's Government of Gibraltar had provided for this to be the case in the public sector from 2016 as a matter of policy. And, Mr. Speaker, in that respect, I refer the House to a circular to all heads of department, which was circulated by the Human Resources Department on the 27th of July 2016. That dealt with issues relating to maternity and adoption leave and sickness absence during pregnancy. In relation to maternity and adoption leave, Mr. Speaker, the reference that this note to all heads of department includes is as follows, under the heading Definition of Confinement. The definition of confinement under General Order 4.1.11 is amended to reflect the birth of a living child or the birth of a child, whether living or not, after 24 weeks of pregnancy. Heads of department must ensure that all these provisions are applied to employees who commence their leave on or after the 1st of April 2016. So that which we made law for all employers in Gibraltar in 2020, we had made a provision internally for us in 2016. I think it's important that that is reflected in the motion. I'm sure it will not be controversial that that should be the case. The next paragraph, Mr. Speaker, on the introduction of groundbreaking legislation in New Zealand should remain as it is. And, Mr. Speaker, then I propose a further new paragraph, which will say as follows. Further notes that His Majesty's Government of Gibraltar already provides for paid leave in the event of miscarriage for its public sector workers, because that is the position generally in the public sector. That doesn't affect the position that the motion is seeking to address, but I think it does put in context that the government is applying to itself that which it is seeking to apply to third parties. It's important that the government has taken the step already, although not in respect of the period below 24 weeks. The next 3 paragraphs remain the same, Mr. Speaker. And I then propose that we do the thing that Mr. Phillips has said he seeks to do, but I believe his motion as drafted does not do. And we then introduce a further paragraph that says this. So after the paragraph that says, notes that whilst employers and organizations, yeah, a new paragraph, a new penultimate paragraph, which would read as follows. Further defines the, open inverted comma, devastating loss of a pregnancy before 24 weeks, close inverted commas, as being inclusive of any pregnancy loss as a result of an abortion as provided by Gibraltar law. Mr. Speaker, this House debated how we should take to our people the vote on the amendment to Section 163A of the Crimes Act, and that should be put to a referendum. That law was passed by this House, and its implementation was a matter that was put, the commencement of which was put in the hands of the people of Gibraltar. A referendum was held, delayed as it was by the pandemic, and the result of that referendum was that what I can only describe by an overwhelming majority, the people of Gibraltar chose that that law should come into effect. And therefore now Section 163A of the Crimes Act is the law of Gibraltar, and a pregnancy may be terminated under our law in the period below 24 weeks. And in that instance, Mr. Speaker, I am sure that no one in this House will argue that the loss of that pregnancy is not potentially as devastating as a loss that occurs by other means. Mr. Speaker, therefore, as a result of those amendments, I would also move that after the amendment that the Honourable, the Leader of the Opposition has moved for Mr. Phillips, we should add a further limb, obviously deleting the or and putting a comma, that would say, at the end of unviable before 24 weeks, which the Honourable, the Leader of the Opposition has just moved, or have undergone a medical termination. And I think that before 24 weeks, Mr. Speaker, can stay where the Honourable Leader of the Opposition has put it, or it can move to the end of this part of the sentence. And then, Mr. Speaker, at the end of the whole of the motion as it stands, I would add the words, for all of the above mentioned instances of the loss of a child or for any of the above reasons. And I'll circulate to honourable members now a notice in writing of those amendments. Mr. Speaker, I am moving that amendment. Before I do, well, I think perhaps before I do, I think it would be helpful to say that in relation to the word a bill, in paragraph numbered 1 of the final paragraph of the motion, we may have to consider whether that bill is attached to a command paper initially to give the Chamber of Commerce and the Federation of Small Businesses and others the opportunity to engage in consultation constructively with the government. Mr. Speaker, that's a comment which is general, but I would now move that the amendment I have spoken to is put to honourable members, and I would circulate to them this, which does not contain the words which were moved by the Leader of the Opposition. So that will have to be read into this, Mr. Speaker. There's one for this side as well. Yeah. Mr. Speaker, I therefore now formally move that amendment and await discussion of it.
I now propose the question in terms of the amendments moved by the Honourable the Chief Minister. And the amendments are going to be circulated, and I'll give all members an opportunity to read through them, digest, and then come back. We will be considering right now the amendments. If anybody wishes to speak, it'll be on the amendments at this stage. Does any honourable member wish to speak on the proposed amendments as proposed by the Chief Minister? The Honourable Lady.
Mr. Speaker, this is why I'm glad that the Chief Minister indulged me in going first before I did, because I really did want to understand where the government was going with their response to this motion. So I thank him. In the main address of my motion, I was going to suggest that although the motion and the amendment to the motion as set by Mr. Phillips, it did encompass all medically induced terminations or miscarriages, that active consideration should also be given to the type of doctor-certified severe psychological distress or related or medically recommended terminations, because this is a relevant demographic of sufferers that should have recourse to similar benefits that serious support intends to provide. Mr. Speaker, as long as abortions in Gibraltar continue to be allowed in cases outside the physically medical, as stated in the motion, we cannot ignore the plight and after effects on women who terminate their pregnancies. Mr. Speaker, some of these women terminate not because of a simple desire not to be pregnant, but because their socioeconomic situation does not allow for more children, or because that future child would be born into a life of uncertainty, scarcity, and strife. Some pregnancies are a result of sexual violence and are born out of toxic, abusive relationships. Some women, Mr. Speaker, become pregnant through rape. Doctors often recommend abortions based on these circumstances of severe psychological distress, and these women deserve no less time off than those who end their pregnancies or have their pregnancies ended for physical or fetal non-viable reasons. I do understand that some may take issue with the fact that the choice of having an abortion is different to the serendipitous loss that happens in the event of a miscarriage, and it is a point I had thought about deeply. But, Mr. Speaker, as long as we as a society require that women suffer from severe psychological distress to be granted permission to have a termination, then we have the responsibility to respond to that severe psychological distress humanely. So I am pleased that the Chief Minister has recognized this and incorporated it in the motion. I think it's in the last paragraph, and obviously, needless to say, I am grateful for this and will be supporting it.
The Honourable the Leader of the Opposition.
Mr. Speaker, speaking as someone who has been in the regrettable position of having lost several children before 24 weeks, I'm very happy that in this House we are able to coalesce around a motion that will deliver a recognition of the devastating consequences of the loss of pregnancy, which are devastating, of course, under any circumstance. And I'm happy to confirm the opposition's support for these amendments for that reason.
I call on the Honourable the Chief Minister as the mover of the amendments to reply.
Well, Mr. Speaker, I'm very grateful that honourable members have indicated so fulsomely their support for the government's amendments. I think it is a demonstration that the government would have engaged positively if it had been communicated to us what the terms of the motion were before it was published, and that we might have been able to see the Honourable Mr. Phillips publish the motion from the word go, in a way that enjoyed the benefit of these changes and could have been expressed to have been moved with the support of the government. But I think it is hugely important that when we are making provision in our law for something as life-changing and devastating as the loss of a child, we should be one of the first places in the world that, given the changes that I have reflected in the amendments to the first paragraphs, which were implemented by us in 2020 and in the government from 2016, and the changes that we will make now, we'll be one of the few places in the world, that will have in our law provision for consideration to be given to those who suffer such loss, whatever the age of their child. As I've said, we uncapped it already. It doesn't matter whether you were 17, 18, or at any age. And now we are opening also the bottom age range, not just to those lost to miscarriage in 24 weeks, but those lost below 24 weeks, even where the termination occurs under the provisions of Article 163, Section 163 of the Crimes Act. The Honourable Lady, in her intervention, has referred to pregnancies that might arise out of violence and might therefore have to be ended, and other circumstances in which terminations may occur. I think it is beholden upon all of us not to seek to set out exhaustively the circumstances that can give rise to a termination under Article 163, Section 163 of our law, and not to prejudge the devastating effect that that can have on the parent that suffers that termination. And so, Mr. Speaker, I think therefore it is fundamental that we have all been able to agree that terminations under Article Section 163, of our Crimes Act should also be within the scope of this provision. And I'm very grateful, Mr. Speaker, to the House for that. And so now, Mr. Speaker, speaking to the motion as amended, well, I think we have to take a vote, yeah.
I now put the question in terms of the amendments moved by the Honourable the Chief Minister. Those in favour?
Mr. Speaker, I call a division. I don't need to seek anyone's consent to seek a division. The rules say any member can seek a division at any time before a vote is taken.
The Honourable the Chief Minister's call for a division.
The Honourable K. Asopardi.
Yes.
The Honourable P. J. Barlan.
Aye.
The Honourable J. J. Bossano. The Honourable D. J. Bossino.
Yes.
The Honourable R. M. Clinton.
Yes.
The Honourable J. E. Cortes.
Aye.
The Honourable V. Dairanani.
Yes.
The Honourable D. A. Feetham. The Honourable J. J. Garcia.
Yes.
The Honourable M. D. Hassan Naon.
Yes.
The Honourable A. J. Isola. The Honourable G. H. Likudi. The Honourable S. E. Linares.
Yes.
The Honourable E. J. Phillips.
Yes.
The Honourable F. R. Picardo.
Yes.
The Honourable E. J. Reyes.
Yes.
The Honourable S. J. Sacramento.
Yes.
Down to the divisions is as follows. There are 15 members in favour of the motion. There are 2 members that are absent, in which case the motion is carried. Motion containing the amendments. We're talking about the amendments, not the motion. We're talking about the amendments which have been moved by the Honourable the Chief Minister. Those have been carried.
Thank you, Mr. Speaker. I'm.
In the form of how the Chief Minister's, but he also asked for the wording that I had moved to be written in, so that as long as that's reflected, because it's not in the paper. It's not in the paper.
So it'll be reflected at the next stage. What we have before us in the House is the motion, the original motion as amended initially by the Leader of the Opposition, followed by the amendments moved by the Honourable the Chief Minister.
So now, Mr. Speaker, I'm speaking to the the motion has been put to a vote, and the motion is now. I've replied on it, and the motion I am speaking to now is the motion as amended. I'm not going to say very much. I mean, I've moved the amendment.
I know, but I don't think you are.
Can I just?
Yes,
I think this will be common ground between us. The motion, when I stand up, the motion is as it was. I then say I want to amend the motion before I carry on speaking to it. The amendment is put, and it is replied to, and then the motion is amended. So I'm still speaking now with the motion as amended. That's how I've always understood it, and how it's always been. So in other words, now it's passed like this, and I am, having moved that amendment, I'm still speaking to the motion as amended. And Mr. Speaker, all I would wish to say, and just to develop, so honourable members know what my thinking is that in respect of this part which says a bill before the House to make provision of, I think that this is a relatively easy bill to draft, or indeed that we can do it in another way. It may not be, because sometimes when we look at these things, Parliamentary Council find that there are many other references in our law than just the ones that we think there are. That can have other consequential amendments, and therefore, Mr. Speaker, the bill may first appear as a command paper, and I want to make that clear so that it's understood that there may have to be an element of consultation on this in order to get it right and to ensure that it does what we want it to do and that we don't cause other difficulties. But other than that, Mr. Speaker, I'm very pleased that we have now before the House a motion which includes all the elements that I've put and for all the reasons that I have put them, and the House will be able to find itself unanimously supporting the motion as amended.
As the original mover of the motion, the Honourable Elliot Phillips has the right of reply. The Honourable Elliot Phillips.
Mr. Speaker, I'm grateful, and I thank all honourable members who have contributed to the debate on this motion, and I'm very grateful for those contributions, that they have ended in a motion which enjoys the unanimous support of everyone in this House. Just to address a couple of the points that have been made by the Chief Minister in his contribution about consult or consultation, I think it ultimately comes down to this. It is bereavement loss. And I take the view that I have by emailing him directly and asking him the question, would this enjoy government support? That for me should be sufficient insofar as the consultation. I'm sure he'll take it to his cabinet and take a view thereafter. And insofar as whether it should prosper and succeed, I think it's, as the Chief Minister alluded to, a plain and simple but important amendment to our law, which might have some nuances or some wrinkles that might need to be ironed out insofar as with the drafts people that are tasked with this. Mr. Speaker, the amendments that have been proposed by the Leader of the Opposition and indeed the Chief Minister are ones that enjoy my fullest support, and I am grateful that we've managed to coalesce, as the Leader of the Opposition has said, around this particular issue. So those affected by tragic pregnancy loss can at least have recourse to a provision in the law which allows them at least 2 or 3 days. That's reference to other jurisdictions. It may be more, depending on what the bill looks like as it comes before this House. And I'm very grateful to all honourable members that have managed to support this bill today.
Yes, you would have had the right to speak, but because the mover of the motion has already responded, then I'm afraid with regret you're unable to speak. Right, I now put the question in terms of the motion proposed by the Honourable E.J. Phillips as amended initially by the Leader of the Opposition, followed by the amendments moved by the Honourable the Chief Minister. Those in favour? Aye. Those against? Carried. The Honourable the Chief Minister.
Mr. Speaker, I move that the House should now adjourn sine die.
I now propose the question which is that this House do now adjourn sine die. I now put the question which is that this House do now adjourn sine die. Those in favour? Aye. Those against? Passed. This House will now adjourn sine die.